there are still millions of people all around the world who are not aware of the United Nations human rights protection mechanism. So in fact, we have an international court that is called the United Nations Human Rights Committee that has a competence to take a decision, a judgment of your internal Supreme Court in order to put it into an international human rights perspective. This might give you a victory that you could bring back home. So if you want to use the international path, there are 5 points you need to know. First, you need to take the list of 115 countries that have ratified the optional protocol to the Covenant on Civil and Political Rights. If you have found your country on that list, it means that you have the right to bring a direct individual action against your government before the United Nations. Now, what to do if you haven't found your country there? Then there might be still some possibilities, some strategies that could help you. The easiest way is to find another country on the list that breaches absolutely the same rights. Then you attack that another country, and finally you bring the judgment on that country back home, and it will be binding on your home country. For instance, right now I have a case against Moldova. In reality, we don't care about Moldova at all. What we need is a judgment which will be binding on Monaco, and Monaco is our country of primary interest. Second, you need to exhaust all domestic remedies. In some of the cases, you will be able to prove that there was no prospect of success to litigate before your internal courts. This is not that easy. The standard of proof is pretty high. Third, there is a deadline. The good point is that the deadline is huge. It's 5 years. If you have decided to use one of those original courts, such as the European Court of Human Rights, the Inter-American Court of Human Rights, or the African Court of Human and People's Rights, then the deadline will be reduced to 3 years. Still a lot of time. Be careful with those regional courts. I was a representative of the impeached president of Lithuania before the regional court and the United Nations Committee. I won both of those 2 cases. However, at the end of the day, my conclusion is that the decision of the impeached president to address the European Court of Human Rights was a huge mistake. It was a waste of time, energy, and money. We could achieve the victory before the United Nations in a much more efficient manner, and it would be much faster. You know, Lithuania is a country in Eastern Europe on the border with Russia. Fourth, there are only 4 official languages: English, French, Spanish, and in cases against Russia, you will be encouraged by the committee to use the Russian language. Don't be in a hurry. The choice of a language is a strategic question. Don't base your answer on your personal linguistic skills or on those of your lawyer. The answer to this question is more complex. It might lead you to a victory in certain cases. Fifth, if you have already tried to address the United Nations and you have got a letter from them that your case is inadmissible, or it is dismissed, or it is rejected, this might be a result of a mistake of your lawyer. If this is the case, then we could still reopen your case. Write me an email, call me, we'll think about that.